Trademarks are often confused with the concept of copyright. Where copyrights are about creative expression, trademarks are about brand identity. The confusing part is that the creation of brand identities itself is a creative exercise. The logo and the brand name, such as Apple, both the Apple logo and the phrase Apple Computer, or Exxon, both the word and the logo, are all examples of trademarks. While their respective websites would be protected under copyright, the brand names and logos themselves are protected under trademark. While collectively all aspects of brand recognition fall under the phrase trademark, there are different categories. For a service, there's the service mark. For things such as the good housekeeping symbol in underwriters' laboratories that certify things, there is the certification mark. And for associations and cooperatives, there is the collective mark. Unlike copyrights and patents that are the sole province of federal law, trademarks are governed by both federal law and state law. Unlike copyrights and patents, there is no specific clause in the U.S. Constitution that covers trademarks. Rather, the authority for trademark protection at the federal level derives from the Commerce Clause. An interesting historical footnote is that Congress first tried to pass trademark legislation on the strength of the Copyright Clause. The Supreme Court struck the law down based on the notion that Congress was acting outside of its scope of authority in its interpretation of the Copyright Clause. Eventually, the Congress passed the Trademark Act under the Commerce Clause. Today, trademark is governed by the Trademark Act of 1946, also known as the Lanham Act. The purpose of the Lanham Act is to help businesses protect and enforce their trademarks at federal level against unfair competition that would either dilute or damage their mark. Now, trademarks also exist at the state level as well. In each of the 50 states, a trademark can be registered. If a business is extremely local, one that does not stray beyond a state boundary, a state registration alone may be sufficient. State registrations are typically handled by a state's corporation bureau or some other similar department. Most often, when the subject of trademark registration is discussed, it is discussed in the context of federal registration. For federal registration, we do so with the United States Patent and Trademark Office, known as the USPTO. Like copyright, the notion of a common law trademark also exists, and it's independent of any specific registration. And that begs the question, do I need to register my trademark? Well, just as the answer was no with a copyright, the answer is technically no with a trademark. But like copyright, it's a best practice to register. First, it can serve as the basis for an international registration should that become necessary. Also, registration serves as a notice-serving function that you own the mark. Finally, registration is tangible evidence that you or your entity owns the mark. Without a registration, you would have to resort to other means of proving both that you own the mark and when you actually began using the mark in commerce. If you recall from our earlier discussions on copyright registration, without the benefit of such a registration, proving ownership and the date of your first use in commerce can be quite difficult and perhaps impossible. For international registration, such as those for Europe, there is something called the Madrid Protocol. Essentially, your U.S. registration can be the basis of a foreign registration. You still have to go through the effort of registration, but the paperwork incident to your American registration would be the basis for your international registration. The difficulty isn't so much with the registration itself, but with the enforcement. Often you have to handle those matters in each country. Also, it is important to note that the Madrid Protocol doesn't preclude country-specific registration, and there may be reasons why you would also want to do that. Should you need to go down the path of a foreign trademark registration, you would be well served to engage the services of an attorney. Often, U.S. attorneys work in conjunction with local counsel in foreign countries. As soon as you begin to use a word, phrase, or a logo in connection with a product or service, you begin to accrue common law rights as to ownership of that mark. There are differences as to how we signify common law versus registered trademarks. A common law trademark uses the symbol TM, and you can begin using that symbol immediately. The registered trademark symbol is a circle that surrounds an uppercase letter R, and you can only use that symbol when the trademark is registered. For services, you use the uppercase symbols SM to denote a common law service mark. But in all cases, Once your service mark or trademark becomes registered, you use the registered trademark symbol again, which is a circle with an uppercase letter R.